Now we're going to turn to the Bill of Rights and other constitutional amendments. At present, there are 27 amendments to the Constitution. We're going to focus only on a small number of those. The first 10 amendments to the Constitution are referred to as the Bill of Rights, and they focus on what we might call negative liberties. Negative liberties means that these are liberties that we, the people, have from the government. They are not liberties that we might think of as positive liberties. A positive liberty might be, for instance, a right to health care, or a right to water, or a right to housing. Those are positive liberties. Those are things that the government is supposed to give to us. The Bill of Rights is framed in terms of negative liberties. These are things that the government can't do so that we may have liberty. We will talk more about some of the various provisions within the Bill of Rights and some of the other amendments in just a few minutes. But just so you understand, we've got the Constitution, we've got the Bill of Rights, we've got the amendments to the Constitution, and then, of course, we've got federal statutes are a source of law in the United States. As I said, Congress enacts these statutes pursuant to its Article I power. We also live in a system of federalism. So in addition to having the federal government, we also have 50 states and the District of Columbia, and they also share the power of governing. And so there are state constitutions, and there are obviously state statutes that are enacted, and any power not conferred on the federal government in the Constitution, specifically delegated, those powers are reserved for the states. And the 10th Amendment of the Constitution explicitly says that powers not conferred on the federal government are reserved for the states. So it's important to recognize that we always have this balance between federal and state power. However, to the extent that they contradict each other, a federal statute and a state statute, or the federal Constitution and a state statute, or even a state constitutional provision, or a referendum, or something like that, Article 6 of the U.S. Constitution provides that the U.S. Constitution, as well as all the laws made pursuant to the U.S. Constitution, meaning all federal statutes, as well as all federal treaties, shall be the supreme law of the land. And that's called the Supremacy Clause. And it's been interpreted to mean that state constitutions and statutes have to conform to federal constitution or federal law. But it is important to recognize that state law is an important source of what regulates us on a day-to-day basis. And then, of course, there are local laws. There are local governments, city councils and county boards, and they also pass laws or ordinances, sometimes paying attention to local matters. And then you should also know that there are these things called uniform laws. Obviously, if you've got lots of different states, it is important, particularly if you're in business, that the states don't have laws that completely contradict each other. Otherwise, it's hard to do any kind of nationwide business. And so there has often been movements to try to create uniform laws. And these are kind of guideline statutes that are created usually by members of industry and nonprofits and law professors, and they all get together and they create these draft laws. And then they go state to state to state and try to get the legislature to adopt that uniform law in precisely the same form so that as people go from state to state, those uniform laws stay the same. The most important of those uniform laws for our purposes, because this is a business law course, is the Uniform Commercial Code, which we will talk about later, but it governs many aspects of commercial law.